Welcome to another edition of Question and Answer with a Criminal Defense Attorney. I am Mark Solomon, a defense attorney in Denver, Colorado, and today's question, what is an open plea? But before we get going, don't forget to click subscribe with a little bell next to it to be notified of future videos, and to click like on this video if you're enjoying this video. So let's get to the question. What is an open plea? Now, before I get going on the actual open plea, I'm going to link this video to, when it's up, I'll link it to what is a stipulated plea, because the two kind of go hand in hand. An open plea is where you're pleading guilty to a charge or charges, and the judge can give you anything from the absolute minimum to the absolute maximum. There are a number of reasons why we're going to get to, that in a minute. But pleading guilty open sometimes is something you have to do depending on where you are. Sometimes it's just better for the case. Anytime you plead open to the court, the judge can do anything they want within the bounds of the law, including the absolute maximum penalty, including jail, prison, what have you, or fines, which means that you really need to do this understanding the risk involved. So let's look at this. An open plea is where a judge can give you the absolute maximum and is not bound by sentencing recommendations. So in other words, if you ever see a plea agreement where the plea agreement paperwork says something like REC probation, that means recommend probation. It's a good chance the judge is going to listen to that and give it a lot of weight, but they don't have to. So that's important to know. So if they say that the prosecutors say that they recommend a certain thing, again, that goes to the aggravation and mitigation and the sentencing arguments from both sides. Now, why would you ever do that? And the answer is sometimes you're better off with a judge than you are with the prosecutor, depending on who the prosecutor is, depending on who the judge is. Sometimes personalities get involved, but also sometimes a defendant with a really great argument for a very light sentence is just falling on deaf ears with a specific prosecutor. I'd love to say there's nothing wrong with that. That doesn't sound right to me, but at the same time, sometimes that happens. And there is nothing keeping you from pleading guilty to the original charges. But remember, if you've agreed to a reduction in the charges, that's part of the plea agreement that you've gotten a lesser charge to plead guilty to. Okay, I'm going a little off on a tangent. Number two, sometimes you've negotiated a lesser charge. Like, for example, if you're charged with a mandatory minimum prison sentence case, like a special offender where you're looking at a mandatory minimum of 8 or 12 years prison, or if it's an assault first degree where you're looking at a decade plus in prison minimum, or let's say it's a second or more ID theft where the judge has to give you prison. Sometimes you can negotiate an open sentence to something else so that at least the prosecutor can argue for something very strict, but you have the ability to argue for something somewhat less, and the judge can listen to both arguments and make a decision about what to do. That's not a bad case to plead guilty open to a court. The third case is some counties and some judges. Like, for example, any plea in Adams County or Jefferson County will be an open plea, meaning that if you're charged with, say, for example, driving under revocation, the maximum sentence is 6 months. If you're pleading guilty to that, the judge can give you 6 months. If you're pleading guilty to any misdemeanor DUI, you're looking at a maximum of a year, and that's just how those counties work. I've talked to some defense attorneys who are just starting out, and they always say, I'm just really nervous about that. But, after a while, you get to the point where you can look at a case, do a good case assessment, figure out what type of a case it is, and then you can get a good sense as to what a client's risk is for pleading guilty, especially in those counties. And so it doesn't technically mitigate the risk. You still have the same risk, but practically that's not usually going to happen unless your lawyer says you're looking at a very lengthy jail sentence. Okay. And also some judges in Arapahoe, I know, also only do open pleas, and sentencing recommendations are just that, recommendations. So be aware of that. So that is what an open plea is and why you would ever do it. Sometimes you have a choice. Sometimes you don't have a choice about an open plea if you're pleading guilty. You always have a right to go to trial. You never have the duty or responsibility to plead guilty. That's one of the things that you talk to an attorney about to try to figure out what to do. Okay, so that is the question and answer for today. If you would like your own question answered in a future video, you can always put it in the comments below, email me, or tag me on Twitter. And as always, you have a right to remain silent. If a police officer asks you questions about what you have, where you've been, what you know, or anything, you have a right to say, "I don't want to talk to you. I'd like a lawyer."